Okay. Um, Greetings, everyone. I'm Catherine Latimer with the John Howard Society of Canada. I'm really happy to welcome you to this John Howard Society Week event. Today, the virtual conference will be focusing on sentencing reform, and I'm quite excited about that. I think that over the last couple of decades, we have been under the, shall we say, American style approaches of longer sentences, tough on crime, which have led to mass incarcerations and other unenviable things in the criminal justice side. So I think now is a good time to be thinking about made in Canada solutions, which are efficient, effective, just, and humane. And I can think of no better panelists than the ones we have for you today to kick off how we could get to better solutions in terms of sentencing and sentencing reforms. Before we get to the panelists, I just have a couple of housekeeping things. One is that the cameras and microphones will be off initially. There will be breakout sessions at the end of the formal panel presentation to allow for more feedback and suggestions from participants. If you can join us for those, please just stay here after the formal panel has finished, and people will be allocated to rooms. And I think that's it. We're hoping that you can join us for that. It is now my pleasure to introduce the moderator for today's panel, and that's Dick Barnhorst. His biography has been circulated as part of the program stuff, but I think the important thing that you should know about Dick is that he was one of the key architects of the Youth Criminal Justice Act, and some of those provisions like the sentencing reforms, which really led to significant reductions in incarceration, which all goes to suggest to me that we can do this, and I hope we can get it started. Dick, are you able to take the mic from now?
If you can hear me, I am ready.
Okay, we can hear you. We can't see you, but please.
Oh, really? I'm on the camera. My image is on my screen.
Ria, can you find out what's happening there? Okay, I'm sure
it doesn't look like it's shared. Let me try this.
Okay, but I would just start, Dick, and then
Okay.
we'll try and fix that as we go along.
Sure. Okay, well, hello, everyone. I would like to introduce the speakers for this session on sentencing, law reform, and policy reform. In the interest of time, I will give very brief introductions. You can find more, as Catherine just said, you can find more information about the speakers in the bios that were sent to you. Tony Doob is a professor of criminology at the University of Toronto. He has a long and distinguished career in criminal justice. I might add that he was very helpful to the Department of Justice team that worked on the Youth Criminal Justice Act, particularly in the area of sentencing reform. Kim Pate is a senator. Prior to her appointment to the Senate, she was the executive director of the Canadian Association of Elizabeth Fry Societies for 24 years. Lisa Kerr is an associate professor of law at Queen's University. She teaches courses on criminal law, evidence, sentencing, and prison law. Now, each of our speakers will have 15 minutes to make their presentations, and that should leave some time at the end for questions. But as Catherine mentioned, there will also be a breakout session afterwards for further discussion. Tony will start us off, and he will be followed by Kim and then Lisa. And Tony, I'll turn it over to you.
Thank you very much. There is a PowerPoint which you may or may not be able to see, but if you can't see it, then it will be available to you afterwards. On the first slide, I talk about in a sense, an overview and the goals of sentencing reform. And I think that these points that I make here are fairly straightforward. The idea is that we're looking for fair sentences, which usually means proportional sentences. We're looking for the effective use of resources. an important point in this is that we promise only what can be delivered. And in that sense, I think that one of the problems that we've run into in the criminal justice system is that often a lot of essentially dishonest statements are made. And part of that has to do with the fact that nothing in life is really perfect, but that perfection is often seen as the only possible outcome of a criminal justice reform. So that I've put on this sort of slogan that perfect is the enemy of good. Uh, in the next slide, in slide 3, you see that the what I've talked about are really the challenges that one has in determining the effect of imprisonment on offenders. People who go to prison are certainly different from those who get community sanctions, and that's always a research problem that has to be overcome. But it also means that we have to look at what imprisonment consists of, what community sanctions consist of, because if we're really looking at the difference between the two, we have to think about what it is that we're talking about, what those differences really are. There's also the possibility that we have to take into account, particularly with community sanctions, that the effects are going to be different for different types of people. That said, there's a relatively recent summary of the literature that looks at custody compared to non-custodial sanctions, which essentially says that there's no real evidence that sending people to custody is going to be a more effective way of dealing with them than something less than custody. That's summarized in something that we put out here called Criminological Highlights. Any of you can get that if you want, and it's available online for you. But I think what's important is that, and we see this in the next slide, that the criminal justice system decisions have to be looked at sort of separate from hindsight. I mean, our problem in the criminal justice system is we always look back and in the public looks back and says, if only something or other had been done, then things would be okay. So that on bail, for example, what we look at and what we hear about are failures of the system. Failures of the system is probably the wrong word, but we talk about offenses that were created by those who were not detained, who then offend in the community. And what we forget about are all of the other people, the people who were detained, who would never have offended even if they had been released, and all the people who are in the community who don't offend. So we hear about one very small part of the problem, and we forget about the other kinds of people who are not caught up in those kinds of issues. A similar problem you see in parole and statutory release, that one person does something terrible and then the whole system is seen as not working because of that one error. We don't see this in other kinds of areas of life. Sometimes, they're car accidents, but that doesn't mean we stop driving cars. They're plane accidents. We don't stop flying in planes. But here in criminal justice, we say, well, we don't have a perfect system, so we have to do something about it. One of the reasons I think we do this is we typically don't compare different policies to one another. And we don't also look at the costs. And I've put here some of the rather dramatic differences in costs, even the community costs that come from Correctional Services of Canada. My own feeling is are probably higher than they necessarily are because of the necessity under their own rules about who should be supervised and how they should be supervised. If you move to the next slide, what I think you see is that we also are pretty cavalier about the way in which we talk about deterrence. The sort of usual thing, if I talk to groups of people and they talk about deterrence, they say, well, harsher sentences would reduce crime. Well, harsher than what, and how do we actually know this? Well, but if you go back a little bit, what you realize is for a harsh sentence to deter, people have to know that they're going to get it. So they have to think that they're going to be apprehended. They also have to believe that that's the sentence that they're going to get. So what you're talking about is people, if logically you're talking about people who believe that they are going to get caught and at the same time know what the likely punishment would be. If you think about this logically, we do a lot of fiddling with maximum penalties here in Canada. And the idea that, for example, you change a maximum penalty from 10 years in prison to life in prison, the idea that there's some group of people who would do it knowing that the outcome and thinking that they're going to get caught if they were going to get 10 years, but that they wouldn't get life in prison. I mean, it's silly if as soon as you start describing what this is really about. So I think that legislative changes are not likely to do much, in part because most of us don't know about the legislative changes. But I think the other thing to think about is that deterrence can easily undermine proportionality. And I think that it's important for us to understand that. The next thing that I think we might want to think about is the kind of evidence that we hear about. And I'll just go very quickly over this. About 20 years ago, there was a change in the law in Florida, and it got, as you'll see in the next slide, publicity here in Canada. This would be on slide 7. That it got publicity because the Conservatives brought up an official from Florida, from the Attorney General's office in Florida, who talked about the impact of this new law, then new law, on crime. And what he talked about, and there's this quote on in slide 7, he said that, you know, in this period of time, there were fewer people robbed. He says, I know there were fewer people killed. He said, I'm a prosecutor. I see this all the time. And if you look at the next slide, in slide 8, what you see is a picture of what actually happened. And what you see is, of course, that after the law changed, indeed, there was less violent crime. But that violent crime rate was at that point in time going down in Florida already. And the idea that something, if you look at that slide, that something was happening that happened in 1999 was critical is nonsense. I mean, logically, if you look at it in terms of numbers, there was more of a decrease before the law changed than after the law changed. So I think we have to think about that. And what we do, unfortunately, is we have somewhat imperfect sentencing laws at the moment, especially with respect to adults. And I'll talk a little bit about kids later on. But when you look at what we change, what the sentencing law that came in the mid 1990s, what we did at that time is to have a fairly strong statement about proportionality in sentencing. And then we said the objectives of sentencing are anything that you can imagine. Sort of all the standard kinds of things. So you have what I sometimes refer to as the D words, denunciation and deterrence, listed there, as well as other kinds of things. And what we've done since then is we emphasize certain kinds of groups for whom denunciation and deterrence are especially important: children, police officers, police dogs, and things like that. But, you know, what we haven't done is to say, well, how do we actually accomplish this? And you see the contrast in the next slide, on slide 10, with the Youth Criminal Justice Act that Dick Barnhorst obviously was in, and Catherine were both very much involved in. And I won't read through this slide, but what I think is important is that if you look at the proportionality statement in the Youth Criminal Justice Act, it says the sentence must be proportional, must be proportionate to the seriousness of the offense, and so on. There are other kinds of things, and they're talking about least restrictive sentence that's available, and so on. But even when that was changed under the conservatives in 2012, when subsection F was put in, if you look at that carefully, what the framers of that did was to say it was subject to proportionality. You can have the D words, denunciation and deterrence, so that it didn't undermine, even though there was a push by the then government to put denunciation and deterrence into the legislation. The reality was that it was supposed to not undermine proportionality. And what we know in the reality is that imprisonment rates for kids started going down in 2003 and have gone down pretty constantly ever since. The next thing I want to talk about is the fact that there really is some very good research showing that harsh sentences don't deter. And the three strikes laws in the United States were a good example, and there was a lot of research on those. And this is just one study. Again, the more detailed summary of it's available to you. But these researchers looked at three strikes legislation in 21 states and looked at it over a number of different offenses, and then said, well, in how many is there seem to be an increase in crime, and how many there's there a decrease in crime? And what you see is variability. So if you want to look, if you're dishonest and want to look for evidence that harsh sentences deter, you can always find them. There's 72 of them in decreases, there's 72 of them that show a decrease, there's 75 that show an increase. And that's a very common thing, that you don't really expect these kinds of changes to have much of an effect. But if you want to cherry pick, you can always find these kinds of effects. But if you look at judges in slide 11, this is one of my favorite studies of these kinds of things, where judges in a particular jurisdiction are randomly assigned to cases. So a case is assigned to a judge, and judges vary. I mean, judges vary a lot, as we well know in this country, in how punitive they are. And in this particular case, the judges varied from giving imprisonment to 23% to about 65%. But when you looked at the recidivism rates of these different judges, lenient judges and harsh judges, there was very little difference. If anything, the high imprisonment judges had higher rates of imprisonment associated with their cases. So I'll skip over the next slide because I'm running out of time, but in other studies, there's the same kinds of things. When you look at incapacitation, what the real problem there is, everybody sees incapacitation as a wonderful idea. The difficulty with incapacitation is shown in the last bullet point, where if you look at a group of people who are released from prison, in this particular case in New Zealand, 30 of them committed a serious offense within 2.5 years, but only 3 of them were initially imprisoned for a serious offense. So you have a huge problem of false positives. It's always easy to find cases where you say, if only this person had been imprisoned for, in the early part of their career. If you look at slide 15, I've given some hypothetical data on this, but hypothetical, but quite plausible data. And this is another example that we always hear. Somebody we hear about, the police often talk about somebody who's been released, 10 different times and they've still committing offenses. And why didn't we just lock this person up for good at the initial stage? And I took some plausible reoffending rate data and said, well, what would happen if you had 30,000 initial first-time offenders who met those kinds of criteria? What would happen after 10 years? After 10 times that they would be given a chance to reoffend? And the answer is, of course, the number of people would would decrease. So I have here, I won't go through the details, some reoffending rates starting with 30,000 and saying after 10 kind of cycles of this, you're going to be down to 43 people, and people are going to be saying, well, why didn't we lock them up? Well, the answer is very simple. The answer is that you would have had to lock up 30,000 of them, most of whom would not have reoffended at all. And those who did reoffend would never have reoffended that many times. So I think these are serious kinds of problems. I'll very quickly make a sort of statement also about the problems of giving judges other responsibilities to reduce crime. That if judges are responsible for crime through rehabilitation, there are a series of kinds of problems in doing that. So that moving from deterrence to rehabilitation doesn't necessarily solve your problems. A separate issue, which Kim may talk about, is giving judges a more active role in the oversight of corrections. But that's a rather different kind of problems. If you turn to slide 17, you see that the problems of what we do with people who have offended in prison has been looked at by a lot of people, including the Auditor General of Canada a few years ago. And what you see is we're not very good. The idea that we're going to send people to prison and we're going to be giving them programs which will deal with their problems, the Auditor General in their review says that that doesn't happen. One of the ones that concerns me most in terms of fairness is the business of whether there's timely access to these programs for a variety of people so that they can be, set for release effectively by the time that they are actually ready for eligible for parole. Finally, I want to point out that when you actually look at some quite controversial issue like parole in slide 18, and I'll just very quickly go over some of these data, that you look at the number of people who are paroled in Canada who commit violent offenses, the number is tiny. In those whose parole ended in the year 2021, 22, there were 9 people who were revoked for violent offenses. There were hundreds or thousands, over 1,000 who successfully completed parole. But those 9 are the kinds of people who you hear about. Those are the ones you hear about. Again, you hear about the failures. You don't hear about the successes because successes don't make news. So nothing's perfect. The failures are salient. The successes are by definition hidden. And what you see in this last slide, in the conclusion slide on number 19, is that the effective solutions may take serious times to develop. But what we know is that we can improve things, but we have to understand that we're going to have to look at these things in a kind of comprehensive, sensible way. And we're going to have to realize that we will not ever have a perfect system. So thank you very much.
Thanks very much, Tony. That was great. Kim?
Great.
We'll turn it over to you.
Fantastic. Thank you. Thank you for that, Tony. And I always feel like I get a master class when I listen to you talk about these issues. And thank you, both Dick and Catherine, for all the work you did on the YCJA. As you know, we've tried to model some of that in some of the work we've been doing is on record suspension and so forth. So I was asked to talk more specifically about the work we've done on what we call Tona's Law. We call it Tona's Law because when the Senate Human Rights Committee was looking at the human rights of federally sentenced persons, a study that was done from 2016 through till 2019, but then really had to be retabled because the government was dissolved and was retabled. We called it Tona's Law because when we visited Tona in the psychiatric hospital where she was detained at the time. She asked us to please make sure what happened to her never happened to anybody else again. And what happened to her is she was a 60 scoop kid, Indigenous, adopted out, ended up in the juvenile system, ended up in the adult system, where she spent more than a decade in isolation, in segregation. And when we finally, literally watched this woman, her mental capacities, you know, uh, I want to say dissolve, but that sounds, I don't even know how to describe it. But those of you who have watched how people deteriorate, how they neurologically, physiologically, and psychologically deteriorate in isolation, you know what I mean. And this was someone who, but for her life experience, could easily have been a law student that I taught or that interns with us, could easily have been going on to do other things. The other thing that's important in terms of knowing Tona's experience, she was one of the women still locked in segregation at the prison for women when the Arbor Commission was doing its work, and is in part her experience that informed Louise Arbor, in my humble opinion, making some recommendations, not just about what had happened to the women who had been jailed there as part of the 1994 events and interventions, but also because of what the way that even knowing that they had broken the law, they continued to do that behavior. And so it was really why Louise Arbour called for the kind of judicial oversight that we tried to introduce in Tona's law. And so Tona now has been out of the mental health system, had a full pardon about a year and a half ago, a full release, unconditional release from the mental health system. But unfortunately, within a few months of that, was diagnosed with cancer and is now in the past few days actually has been labeled palliative, that they can no longer do any treatment. So long before she had cancer and long before she was out of the mental health system, a number of us agreed that we should actually look at this. And at the same time as this was happening, there were two cases that many of you know went to the Supreme Court of Canada, one from BC, one from Ontario, about the use of segregation. And one of the things that we had tried to do in the early stages of those cases is to actually take a position on getting rid of segregation. Interesting, and I just had this discussion with a group of lawyers and judges at the Wilson Moot in Toronto last week. People weren't comfortable taking that, what they saw as a leap towards saying no segregation, despite all of the evidence that within as few as a few hours, you can see permanent irreparable damage from segregation. But one of the ways the government avoided having to go to the Supreme Court of Canada on that case at a time when there was mounting evidence from the correctional investigator, from the work the Senate was doing, from the work that many of you were doing, and the many court cases that were developing across the country, as well as the work of the Mental Health Commission, which I know you heard about yesterday. One of the things they wanted to do is to, I think, not have to face the Supreme Court of Canada and get a decision from them about these issues. And so they brought forth Bill C-83. Bill C-83 was characterized as eliminating the use of segregation. We all know it basically renamed it and removed the limited oversight that existed for, in particular, disciplinary segregation and even administrative segregation, and as well as administrative segregation, and substituted the Ministerial Advisory Committee, which I commend to you the work of Tony and others in the reports showing basically not only did they not achieve an elimination of segregation, but they in fact perpetuated the illegal detention of folks and the harmful results of that, human as well as, I would say, fiscal costs of that. In addition, the correctional investigator, of course, has documented this. And now we have some of the independent external decision makers who are seen as the third party independent voice, who are independent body that was supposed to be the oversight as well of structured intervention units, now clearly articulating that, or a number of them, particularly, not surprising, those who have not had their contracts renewed, that again, when they were making decisions to actually have people released from structured intervention units, there are many examples where that wasn't followed. And I again commend to you the research that Tony's done on this. So we started monitoring as soon as one of the things a number of us had been going into the prisons, and there are now 38 senators who have gone into the prisons and met with folks. As recently as last week, a number of us were in Collins Bay for Black History Month, as well. Senator Clement, Bernadette Clement, who's former mayor of Cornwall, has been doing election issue discussions with folks across the country, going in with Rick Sauvé. And so a number of us have been going into the prisons, and after our amendments to Bill C-83 were not followed, and the amendments, if you want to know what they are, they're basically what Tona's law is now, what was Bill S-230, basically requiring within 48 hours, if corrections wants to keep someone in segregation for more than 48 hours, they go to court, very similar to the types of bail provisions that exist. We also put in place mechanisms for, a provision that, a presumption that people with mental health should not be ever in isolation and should instead be transferred out using existing mechanisms like Section 29 of the Corrections and Conditional Release Act, as well as a stepping up of the provisions of Sections 81 and 84, not just for Indigenous folks, but also for others who are in the system. And then finally, a remedy for those who, where corrections does not follow the law and the law is breached, a remedy that would allow folks to go back to court to have their sentence and or their parole and eligibility revisited. So that's basically the provisions. That was what the Senate recommended, or not recommended, we amended Bill C-83 back in 2018. 2019, the federal government rejected those amendments, and so we brought forth the bill. And it was, when Parliament prorogued, it had passed the Senate, and it was at the House of Commons awaiting movement through the House of Commons. Now it's died on the order paper, so we'll reintroduce it. My hope is that we'll be able to have it go fairly quickly through the Senate this time around. And linked to that, many of you know that I didn't come to, contrary to what many people thought, I didn't actually come to the Senate to work on crime and sentencing legislation and policies, because one of the things I came here to do was to work on developing the social, economic, and health systems that allow people to stay in community and prevent more people from being abandoned to the only system that cannot refuse them, our prison system. And those of you going to the prisons know I'm not telling any of you anything new, that our prisons are full of the people who are failed by every other system. So my purpose in being here really was to focus on those issues. But given the work that I've been doing, of course, I will continue to also introduce provisions like this. We'll be reintroducing the record expiry bill. I noticed with interest that the new Black justice strategy that was released yesterday is so reminiscent of what we promised Indigenous people, what we promised women, what we promised youth in successive decades of reform, and a whole bunch of money being put in to help people apply for pardons or for record suspensions instead of just making them automatic. So we'll continue with that. And we'll also reintroduce the bill that would allow judges the discretion to not impose mandatory minimum penalties, because we need to do that. But at the same time, for those of you wondering why I was sponsoring the pharmacare bill, why I'm putting forth guaranteed livable income, it's one thing to say we need to dismantle, to decolonize, decriminalize, and decarcerate. But if we don't build up a community for people to be actually supported in a state of non-incarceration, then we see what happened in BC when they went with decriminalization but didn't build up the requisite supports in the community. It then becomes a rationale for reintroducing the very policies that are ineffective that Tony has identified. So I'll stop there, and I'm very interested in the discussion. I do apologize. I'm co-chair of the Anti-Poverty Caucus, and we have a meeting that starts at 2:00. So I apologize that I'll have to leave then, and I will just do so quietly if we're not done. So, but thank you very much, and thank you to everybody for all of the incredible work you do.
Thanks, Kim. That was very interesting. We'll now move on to Lisa.
Thank you. Well, hello, everyone. Thank you for including me today, and I'm grateful, as always, for this chance to learn from Tony and Kim. So I want to take most of my time to explain where I think we're at in terms of the constitutional law of sentencing. Specifically, I'll focus on the status of mandatory penalties, and I'm going to do that by discussing 3 Supreme Court of Canada cases from 2023, really significant cases handed down. And I think looking at what those cases establish will help us be in a good position to analyze the legality of any proposals from a possible Conservative government moving forward. Before I do that treatment of the law, I want to just comment briefly on the current political moment and the prospect we're facing of a new Conservative government coming in and picking up on the Harper government legacy. So at this moment in time, we have this very long list of policies passed by the Harper government that have now been invalidated in the courts. It took many years, but the story is really now complete, and the list of policies that were struck down is long. We have on that list mandatory victim fines, mandatory penalties for drug crime, de facto life without the possibility of parole, automatic placement on the sex offender registry. A handful of things have been upheld, notably the limits on conditional sentences, just barely upheld in a 5-4 decision. And of course, some changes that were implemented could not be challenged using the charter, but a lot was, and most was struck down. And so I think it's actually a really important moment to remember that all of these policies that were eventually struck down at the Supreme Court of Canada level took hundreds and hundreds of lower court cases, extensive judicial resources, Crown resources, legal aid resources, in order to effectively get back to a status quo that is just without these extreme penalties. And I really shudder to think of how much justice system spending went into that. And I think the idea of Mr. Poilievre proposing a return to this set of strategies, namely passing sentencing laws that they know are very constitutionally vulnerable, I think we should really be pointing to the cost and the waste, and that the Harper legacy is really one of so much litigation at great public expense with really so little to show for it. And of course, there's also the additional point that these laws are often just not required. So many legislative interventions into sentencing law are really directing judges to do things that they already have the discretion to do in appropriate cases, and that they're in fact highly motivated to do in appropriate cases. So the most recent proposal we saw was this idea of a mandatory life sentence for fentanyl trafficking. Completely unnecessary. And I'll just say, I think ordinary Canadians might sort of hear his proposal and think, yeah, we should have a law that really severely punishes high-level fentanyl dealers, right? Maybe even life, right? The ones that are really running the show, making a lot of money, let's incarcerate them. And I think Kim had really an excellent editorial on these issues, and her central point in that piece was that number one, this law really wouldn't catch the high-level people because it was based on the amount of drugs alone. And it's actually the low-level, often exploited, often drug-dependent people who are the ones carrying the drugs around in large amounts. But perhaps more importantly, we already have this law in place. So the Supreme Court had a case on fentanyl sentencing from 2021, and I want to just read you 2 sentences from that decision from paragraph 101 of the Paronto decision. So this is Justice Moldaver. He writes, fentanyl trafficking and large-scale trafficking in particular are a source of unspeakable harm. Accordingly, while the range of sentences currently imposed for the directing minds of large-scale fentanyl operations straddles the upper single digits and lower double digits, sentencing judges should feel justified, where circumstance warrant, in applying a higher range consisting of mid-level double-digit sentences, and in particularly aggravating circumstances, potential sentences of life imprisonment. So the authority to impose those sentences is already there. And in my view, sentencing judges have been directed to go all the way up to life in the appropriate case. The question is it an appropriate case? And the problem with the law proposed by Mr. Polyev is that he would tie this mandatory sentence to simply the drug amounts. The amounts are way too low, number one, but even if they were higher, you wouldn't get at the high level people with this law. So let me turn now to the law on mandatory minimums. I think this is important to understand because, you have to kind of understand where the law is at in order to be able to make claims about how proposed policies are likely just to result in more costly and hopeless litigation. So there were three big cases from 2023. They're called Hills, Hillback, and Bertrand Marchand. I will not talk about them in detail due to time. I'm going to take you right to the finish line in terms of what I think they establish. And I'll just say in Hills and Bertrand Marchand, the mandatory penalties were struck down, but in Hillback, the penalty that was at issue there was upheld. So let me say what I think is sort of the good and the bad from these cases. And I'm sure many of us know this, but just for those who don't, these are all challenges to mandatory penalties brought under Section 12 of the Charter. That's the section that prohibits cruel and unusual punishment. And the basic test here, which has been the law for a long time, is that a penalty infringes Section 12 if it requires a grossly disproportionate penalty for either the offender before the court or in the case of a reasonable hypothetical scenario. So that's the test the court's dealing with here. So let me say what I think is good about these 2023 cases. So I'll say three things about what they do to the jurisprudence in this area that I think are significant. First, the court said, when it comes to how you consider the hypothetical scenario, a scenario in which it's reasonably foreseeable that this law will capture someone and give them the mandatory, that you're allowed to consider a range of possible personal mitigating circumstances. So even though you might be striking the law down on the basis of a hypothetical, you can think about the kinds of mitigating personal circumstances that sentencing judges in this country see every single day, right? And so we're talking mental health issues, homelessness, poverty, childhood disadvantage, racism, certain kinds of background facts that Indigenous people often have. And when we're analyzing whether this could be a disproportionate penalty, you are allowed to think through those very common everyday features of the circumstances of offenders. That was a hard-fought issue for many years, and it's really important that that's clear now. Two, Indigenous background has to be given significant weight, the court said here, both in terms of a possible reduced moral blameworthiness and in terms of the deleterious effects of imprisonment on Indigenous people. This is a very powerful clarification, I think, in the jurisprudence as well. Before 2023, we really had no discussion of that from the court in the mandatory minimum context. And so I think the fact that possible Indigenous background and the kinds of mitigating systemic factors that are often presented there, I think is a powerful tool for challenging mandatory minimums. Third, the judges are directed in these cases to think not only about sort of the length of the sentence, right, its temporal dimension, but to also think about what the experience of punishment will actually be like under the mandatory penalty. So the qualitative aspects of the punishment. What will prison be like for this person? person. And the court said you can think about how certain vulnerable groups are more negatively impacted by prison, whether that's, again, due to race, due to mental health, due to physical disability, and so on. And the court also directs us here to think about how a community-based sanction, a non-custodial penalty, might actually have qualitative terms to the penalty that might better enable access to things like counseling, rehabilitation, and so on. So I think that's also really significant. The court has invited judges, when you're looking at the proportionality of a mandatory penalty, think about what it's actually going to do for this person, what it's going to be like for them, whether it's going to be more harsh for them than for someone else. Think about those personal mitigating circumstances and so on. So I think that's all very powerful and will make many mandatory penalties very vulnerable. A final thing I think that's good from these cases that we got is just clarity. I think we got clarity on exactly the mandatory penalties that are likely to be struck down in future. And so here's the headline. When a mandatory penalty replaces what could have been a penalty of probation or a non-custodial penalty or a conditional sentence with imprisonment. So what I mean by that is if the mandatory, say, requires a year in jail, but the offense is such that some sentencing judges might have wanted to impose probation for that penalty, depending on the circumstances, that's going to be a very vulnerable mandatory. And it kind of goes to themes of some of Tony's work, which is that Canada has kind of has long had a real attitude of restraint toward the use of imprisonment as a penalty. And we're really supposed to consider whether alternative means of punishment might do the trick. And so the court is saying if the mandatory, even if the mandatory is very short, right, even if it's only 6 months, well, a lot of the 6-month mandatories, probation might have been appropriate. A CSO might have been appropriate. And here the court says, we're not comfortable with mandatories that require jail custody when a judge might have diverted away from custody. So I think that tells us actually that even very short mandatories, in fact, the shorter, the more vulnerable it's possible. So I think that's a really important bit of clarity. And I don't think any of that was kind of said by the court before 2023, although I think it makes good sense of the pre-existing case law. My last point, the negative, the bad from these cases. And I'm going to point here to the Hillback decision. So Hillback is the first case in 16 years in which the Supreme Court of Canada upheld a mandatory minimum. And the mandatory here was robbery with the use of a prohibited firearm. And what's really striking about Hillback is that this was the first case involving an Indigenous person with very strong, compelling background and systemic factors, Gladue factors, that had ever really been before the court in terms of looking at a mandatory minimum. And it's interesting, counsel didn't even argue in this case about reasonable hypothetical scenarios because I think they thought the circumstances of the offender before the court were so compelling and were really demanded mitigation that the most powerful thing to challenge this mandatory was really just to rely on his circumstance. But it's a very striking case because the court, not only this is the first case they uphold a mandatory, but more than that, the court actually says that the fit penalty for Mr. Hillback, because of his personal circumstances and the impact of imprisonment on him and some mitigating factors, that the fit penalty for him was 3 years. But the mandatory in this case was 5 years. And what the court does is it says that they're willing to tolerate that gap between the fit sentence and the mandatory here. And it's striking because in past cases, you saw the court, strike down a 1-year mandatory in the Lloyd case because probation could have been appropriate. And so we had this sort of maybe false sense from the past cases that the courts were not really willing to tolerate much of a gap between the fit sentence and the mandatory. But here there's this pretty extraordinary gap between 3 and 5 years. And the court upholds the mandatory and says basically it's because of the seriousness of the conduct. And in looking at the scope of this robbery offense, the court says it really applies to a relatively narrow set of violent behaviors. Conviction requires a deliberate and specific act with a defined harm. It's just a much tighter offense, is what the Supreme Court says, with much more sort of deliberate misconduct than in some of the past cases where they struck mandatories down. I'll just say the dissent in this case was pretty convincing to my mind. One of the things the dissent emphasized was that Mr. Hillback made a choice to go in with an unloaded firearm to do this robbery, and that this offense gives you the 5-year mandatory no matter whether you made that choice to load your weapon or not. And obviously the risk of harm is greatly reduced with the decision he made to go in with an unloaded weapon, and that the dissent would have struck the mandatory down on the basis that it really covered, it captured offenders who were at the lower end of moral blameworthiness. But I think we learn maybe from Hillback that when you're talking about the more serious offenses, right, where the person is headed to penitentiary one way or another under either the fit penalty or the mandatory, that the court has indicated to us more of a willingness to tolerate a gap between the sentence that a trial judge might see as fit and the sentence that Parliament has insisted that courts impose. So those are my thoughts. I'll leave it there and happy to engage in discussion.
Thanks very much, Lisa. And congratulations to all of the speakers for staying within the time limits, pretty much. We're now going to open the session to questions from the audience. My understanding is the way you indicate you want to ask a question is to click on the raised hand icon on your screen. So we're now open for questions. Looks like we have one. Is that Catherine Latimer?
Let me turn my microphone on. Yes, I have a question, and it's actually for Kim. And this is going back to the provision where she is suggesting that sentencing judges should be able to reduce the sentences imposed by the courts if there was an abuse that a prisoner experienced during the administration of a sentence. I was wondering if you could just comment on that, Kim.
Sure. Well, the reason we put that in there was very much what Louise Arbour talked about as well. The fact that, and many cases, I'd be very interested in Lisa's take on it. And that was, thank you, Lisa, for a masterclass in the
great,
sentencing law as well. The reality is, if you spend most of your time in segregation, you are serving a much more serious sentence than what the judge intended. When a judge sentences you to jail, they are presuming that you will be separated from society, but we call it corrections because we expect people are going there and at least there's some attempt to provide supports to address the issues that brought them there in the first place, not that they're being placed in a situation that is increasingly detrimental to them and therefore to society. And so the fact that they essentially have their sentence increased by being placed in isolation would then justify going back and reviewing the case to determine. And I liken it to the pretrial detention arguments that are made that if someone spends a bunch of time in remand with no access to programs and services, then that's the rationale. It's a more secure form of detention, plus they're awaiting trial. So that's what we were thinking. So
I would just add to that I think the logic of Kim's proposals here and the bill is very much endorsed by the Supreme Court of Canada in the Hills decision. You see there Justice Martin say that the severity of incarceration, which would obviously include, right, segregation and abusive experiences that you might undergo there, that is all highly relevant to the proportionality of the sentence. And Justice Martin is directing sentencing judges to think about those things prospectively, right? And I think that's whether you're analyzing a mandatory minimum or you're just imposing sentence. I think she's authorizing judges to say, think ahead to whether this is the type of person who will be victimized in the prison context, who will be held in isolation and so on. And so if that's relevant at sentencing, then why, a sentencing judge is not always going to be able to predict that. Where they can consider it, but what about where it happens and they didn't predict it? What is the remedy then? You can't go back in front of the sentencing judge to get a sentence reduction. And I think that's the logic of Kim's bill, is that there should be a remedy there.
Okay, thank you for that. Are there any other questions?
No, but Lisa's just reinforced why exactly I wanted her to come testify. The downside of not being able to get everybody you want to testify at committee. So maybe we'll get you this, be successful this time around.
Dick, I think Ben has a question.
Oh, okay, Ben, go ahead.
Hey, I did not have a question. I just wanted to flag that someone's asked a question in the chat.
Oh, well, can you share that with us, Ben?
I can. So someone has just asked, my question is for Indigenous people who are sentenced without a GLADU report. What can be done? I ask because I'm a prisoner advocate and prison wife. I see this lots. My husband was denied a GLADU report by the judge who stated he was getting life and did not need one. This seems an injustice, as my husband suffered, as many do, from mental health and past trauma reflective of GLADU factors.
Well, the twins' decision says that they should be taking it into account for parole decisions. So, and I'm very sorry, I'm now going to deke off to go chair this other thing. So thank you, everybody. Fabulous to see you. Great work, and we'll talk soon.
Thanks, Kim.
Yeah, perhaps I'll just finish what I think was Kim's thought there, that you do need a GLADU report done. It can be done in the prison context as well. And I would there's also, it's in the CCRA now, that for every correctional decision that's made with respect to an Indigenous person, the background and systemic factors have to be considered. And so it doesn't have to be necessarily by way of the production of a GLADU report. I mean, even at sentencing, it's not mandatory that a judge get a GLADU report. But what is mandatory is that the information that's relevant to the circumstances of an Indigenous person be before the court. And so in the correctional context, I think that is also the rule now, but it can be collected by an institutional parole officer. It doesn't have to be through the production of a GLADU report. But I would suggest that when this gentleman is approaching his parole eligibility, that may be a time to engage Aboriginal Legal Services and actually get a proper one produced, because it would be highly relevant to parole decision making because of the twins' decision.
So I think we have one other question, and it's the other Ben.
Yes, thank you for the presentations. Of course, all three of you are fantastic in this area and really appreciate all the work that you do. I think, we know how far the practice is in criminal justice from what the evidence suggests, and in many cases from what, as Lisa suggested, from what the law tells us we should do. So my question is more around the politics of this. What are the strategies we can use? What are the range of strategies that we can use to try to move the system closer to being evidence-based, given the politics around it that are so difficult? Obviously, there's more than one opportunity there, but as people who've thought about this a lot, I'd be really interested in what your views are on it.
I think Tony should speak to political strategies.
Yeah, no, that's a difficult one. I mean, I think that the problem is that a lot of our criminal justice legislation is put in not because there's really a belief that it will improve public safety or improve the criminal justice system or improve fairness, but rather it's put in because it's good politics. And the good politics what makes good politics may vary with who's in power, but I think that the difficulty is that we've got a system where there are, literally hundreds of things that are available. So it's always possible to find yet another offense that you can put a mandatory minimum penalty on, or you can, at the same time, just simply get rid of some mandatory minimum penalties, as was done by the Liberal government. But what's not being done is to look at these things as a whole. And I think I skipped over it probably too much, but I think that we can learn from our experience with the Youth Criminal Justice Act. And the Youth Criminal Justice Act came in at a time, I mean, I'm old enough to remember this, but in the 1990s, kids were seen as if they were devils who were looking to commit serious kinds of crimes, so that there was talk about very serious things being done by kids, which of course is always true. I mean, there are like 50 to 70 homicides a year where a younger person is implicated at least in the original charges. So we do know that kids can do things that are bad. But what we aren't doing is to say, well, what is it that the Youth Criminal Justice Act can do? Or what is it that youth justice legislation can do? And what we decided what Canada decided in 2003 when this law came into place was that there was a limited amount that the Youth Criminal Justice Act could do, and that limited amount was going to be controlled in various ways by saying that imprisonment was the what you do when you run out of other things to do, and that there were provisions that were put in. But I think the other part of it that we forget about was not just the legislation, but the fact that legislation was being considered for a 4-year period from March of 1999 until it became law in April 1st of 2003. And even when the law and various things that happened between 1999 and 2002, but the law, received made it through Parliament in very early 2002. Catherine can correct me or Catherine or Dick can correct me, but I believe it was in February 2002, and there was a decision by the then government that there was going to be yet another law to try to explain to people why this law made sense. So in a remarkable way, when the law became law in April 2003, there weren't pressures to lock up every kid who had done something bad, that people were kind of on side. But that was a 4-year exercise in training, in getting people to think about youth justice in a different way. And what do we do with mandatory minimums? Well, mandatory minimums are a great example. Well, we add one here and we add one there, and we change this one and we change that one, and there's no kind of overall look at what we should be doing. Somebody, I think it was Lisa, mentioned the idea of having an escape clause for mandatory minimums. Well, the various escape clauses have been looked at around the world, and they've been looked at within Canada as well. And I think that would be one way to deal with it. But I think what we really need to do is to think about what sentencing is all about. And if we thought about what sentencing was all about, forget about the rest of the hundreds of sections of the criminal code. If we thought about sentencing, what we might be able to do is to, have a serious discussion, the way we did with youth, about how to accomplish reasonable, achievable goals. And reasonable, achievable goals do not mean that we're going to have perfection. But what we're going to have is a better system than we have. But that means that the government's going to have to decide that, some sort of quick political thing is not where we're going to go. And where we've been going, I would argue, not just during the conservative period, but during the more recent liberal period, is on quick fixes. and quick fixes on a variety of different things. So we add this section and we add this section. We say that this is an aggravating factor in sentencing. Well, why is it an aggravating factor in sentencing? I mean, why do we make some of these things aggravating factors in sentencing? Why don't we just fix the whole process and think about what it's all about? But, you know, that means really going back to kind of basics in criminal justice policy rather than these sorts of little fixes to section whatever. So I'll stop.
For what it's worth, I totally agree with you, Tony. We don't have time to get into a real discussion of that, though. And we're 5 minutes past our time. So, Catherine, does it now go into a breakout session? I can't hear you.
You're muted.
Mic isn't on. After all this time, I'm still talking without the mic on. I really want to thank you, Dick, for chairing this. I know it was difficult when people couldn't really see you, but you did a great job, and the panelists were fabulous. And I think there's a lot to churn over here about how we move this forward to try and get better sentencing principles as we move forward. I think it's key. I think it's extremely important. Yes, so we are moving to breakout sessions. So if you can stay for those, then please just sit tight. And if you can't stay, thank you very much for having joined us up to this point. But Ria will do something magical, which will sort us all into breakout rooms if we can just wait for a couple of minutes.